Good morning from me and the balloon that will not die. We're just, at this point, we're just like taking bets over under how long that thing is going to last. But I like it there. It gives me some sort of strange comfort. Anyway, good morning. We went the entire day yesterday without talking about Lively Baldoni, which I desperately needed. And I'm trying to kind of bring the temperature down on some things. Because there are some obviously very big and emotional issues wrapped up in this case, but I want to make sure that I am not contributing to making everything a big emotional issue when a lot of them are really pretty typical run-of-the-mill stuff. So what I'm going to do this morning is we're going to do a little reset on where we are in the discovery process and how that works. And then I'm going to, at the end, talk about a couple of the decisions that have been made by the judge this week and late last week on some of the discovery issues that are out there. So I learned last week when I posted about, how you don't necessarily have to turn over everything that you have in discovery in a civil case, that there is a lot of misunderstanding about the civil system versus the criminal system, right? In the criminal system, there's many more, again, there's constitutional rights in play, right? So the prosecution has to turn over anything that could potentially be exculpatory. There are rules and regulations about where you can get information from, how you can get information, and what you have to share. It's called disclosure. If you know, you know. So in the civil system, it's a little bit different. In the civil system, when you get into discovery, you are trying to discover everything that could possibly be out there that relates to the claims and the defenses raised by all of the parties in the case. If you learn nothing else from me, learn this. The complaint and the answer to the complaint in a case are the blueprint for the trial. People often say, how do lawyers know what they have to prove at trial? You are literally taking the complaint and saying, I'm going to prove every single thing that's in there. And if you're the defendant, you are either trying to poke holes to keep them from proving those things, and or you have affirmative defenses that you have pled, and you are trying to prove those to either lessen or eliminate your liability. So the complaint and the answer are the blueprints for the rest of the case. Now for Lively's complaint, or the original complaint in this case, we have both. We have her amended complaint, and then we have answers from Wayfair, Able, everybody on that side of the case that they filed with many, many affirmative defenses, many of which mirror the claims they tried to bring affirmatively against her. Now, defamation is not an affirmative defense to sexual harassment, but a lot of the things that were argued, unclean hands, which is basically just saying you had bad behavior too. You never told me about this. You caused some of this damage yourself. All those kinds of things. Maybe I'll do an affirmative defenses video. But all of those things are still in the case to some degree as affirmative defenses, which means that discovery can be gathered on those issues. So they're not just gathering discovery based on what Lively's claims are and what remains with Wayfair's claims. They're also gathering information based on what the defenses to those claims are. Now we have a hole because we haven't yet gotten answers from Lively to the claims against her. Obviously, a bunch of them were just dismissed. There are a few left, and we just haven't gotten to that stage yet. But the point I'm trying to make is that discovery is pretty broad. It's trying to gather any information that could go to any claim or any defense in the case. And this is the really critical thing about discovery. In discovery, admissibility is not the issue. Relevance is the issue. If something is not admissible, if something is hearsay, if something is problematic or otherwise might not be admissible when you get to trial, that is not a reason that you can't discover it. Right now, it's just about relevance. Is it relevant to this case? And is there any kind of protection or privilege on it that would keep somebody from seeing it? But we do not determine what is and isn't admissible evidence at the discovery stage. You gather all the information and then you sit down and say, okay, what do I need to use at trial? And then you deal with the admissibility. So everything is on the table at this point. In a civil case, to a large degree, where you get the information from and how you get it doesn't really matter. And I know this upsets people about the legal demand for papers, and we're going to have to see how that shakes out. But unlike in a criminal case where you have constitutional rights about how information in a criminal case is gathered, in a civil case, you do not necessarily have to worry about the propriety of where you got it from, as long as you can authenticate it and as long as it's admissible. You can get information from anywhere. You can get information in a plain envelope slid under the table to you at a restaurant, right? And still use it in a civil case as long as you can authenticate it. So information can be gathered in front of people. It can be gathered behind closed doors. It can come from generally anywhere. Now, I know some of you are thinking, but what about, this has happened twice in the last week with the emotional distress claims and now with the Wayfair internal investigation, what about the judge saying, well, you can't use that if you don't turn it over? So if someone asks you for something, remember, as I've said before, that in civil discovery, in order to get the information, you have to ask the right questions. You have to ask for it. So if someone asks the right question and says, I want this information because it is relevant to your claims, and you say, no, I'm not going to turn that information over because it's privileged or I have some other legal objection to it, then you will be prohibited from using it down the line because you can't hide the ball, right? But if nobody asks, you don't have to give it over. And here's the thing. Everyone is a dick in discovery. Big cases, medium cases, small cases. Now, some people are bigger dicks than others. I've dealt with people who are just absolutely horrible, who would, file a discovery motion at 4:30 on Friday afternoon and then call and leave me a voicemail and be like, have a good weekend, click, right? Like, some people are just assholes, but there's always a lot of push and pull. And to be honest, like with criminal litigators, criminal lawyers, a lot of their magic is in the courtroom, obviously, because, they have hearings and stuff, but there's really like one big thing. Most civil cases do not go to trial. And so a lot of what civil litigation is discovery disputes. And so this is where the lawyers really show off their style, right? So everyone is a dick. What is happening in this case is not out of the norm at all for a case this big with stakes this high on either side. Now, you can choose whose style you like better, but the fact that they're sending these motions back and forth bitching at each other is very, very typical. So there's one, remember when you ask for discovery and you don't get it, or they say, no, I object to that because, and you have a dispute and you can't work it out, then you file what's called a motion to compel. There is a big motion to compel out there right now about the Wayfair people turning over information about third-party creators. I'm going to do another video on that. It deserves its own video. And there's been I think there's been 2 motions to compel that happened in the past. But there are 2 discovery motions that have been ruled on in the last week. And here's what they're about. So one is the lively parties sent some subpoenas to third party. Remember, if someone's not in the case, you have to go through a whole subpoena process. Those people do not want to respond to those subpoenas. And so they're filing a motion to compel responses to those subpoenas. Actually, I think those people filed a motion to quash. I don't remember. Anyway, they're trying to get those third-party subpoenas responded to. The judge said, remember in Venable, they had to file it in D.C. because they were supposed to produce the documents in D.C. He's like, these are supposed to produce documents in L.A. and Atlanta. Get the shit out of my courtroom. No, thank you. The other one is Lively had asked for this internal investigation of Wayfarers that they're doing with a hired law firm to investigate workplace issues. Wayfair said, no, that's attorney-client privilege. The judge said, you can't have it. It's attorney-client privilege. But remember, Wayfair, if you don't turn it over, you cannot use it later. So they can just kick that can down the road. So that's sort of a reset on discovery. Let me know what questions you have, and I will do my best to answer them in a calm and soothing voice.